Good morning, everyone. Good afternoon. I know we're all coming from different spaces, but thank you for joining today. My name is Nikki Gable. I am a program manager here at Michigan Public Health Institute. We are here in day two, the what of RFW, Recovery from the Workplace Policy Essentials. We have our special guest, Joe McGuire, who's joining us today, and I will do a formal introduction in just a minute. But I do want to just do a very quick sharing of our objectives today. We are going to do a very quick overview of what the Michigan Recovery from the Workplace is, what a recovery from the workplace is. We're going to dive into the meat of this presentation very quickly after that, talking about the core components of an effective workplace policy. We'll dive into drug testing, reasonable suspicion protocols, return to work processes, employee commendations, and discussion of safety sensitive roles as well. So Joe will be helping us out with all of that important information. But before we do, we just want to kind of think about why we're here and what brings us to having these very important conversations. If you were here for training or day one, we talked about this. This is going to be a review of what we already talked about. I love to say, it takes about 7 times to see something, hear something before it starts to really resonate. So I'm going to take this opportunity for a second time for you. So thinking about substance use disorder, it's really important for us to understand that it is a treatable chronic medical disease involving complex interactions among our brain circuits. There's a lot of things that can contribute to substance use disorder, but it's also really important to understand that a lot of people, unfortunately, are living with substance use disorder. In 2024, 48.4 million US individuals were living with SUD. Substance use disorder is not a moral failing. It's not a lack of willpower. It is a complex disease. And a lot of people are also working with that complex disease. And so that's where our mission really comes forward, is to think about, as employers, do we have an opportunity to be able to really make a difference in this space? And there's a lot of ways that we can do that. And we'll talk a little bit of what the Recovery from the Workplace Initiative is trying to do in that space. But there are some, obviously there's a lot that goes beyond what a workplace can do. Recovery from a substance use disorder is a process of change, and there's a lot of complex, again, things that go into recovery. Employers have an opportunity to provide some support in that space. 23.5 million Americans 18 and older were in recovery from some form of substance use disorder. Since we're here, thinking about workplaces and occupations, you have a list here of a number of occupations that are impacted in some way, shape, or form, or have individuals who are impacted by SUD. There's obviously, you can see that it goes up into different industries that have a higher rate of substance use disorder. There's a lot of reasons for that we can think of, whether it is the nature of the job. A lot of it has to do with kind of those workplace struggles that happen and how we set it up as a workplace, but it's also an opportunity to think about how we can change that within our workplaces. One of the important reasons why we want to share all of this information is because a lot of people who need help don't necessarily receive it. And there's a lot of reasons why and how workplaces can remove some of those barriers. Because there's so much stigma that is associated with substance use disorder, we have a lot of work to do in terms of how we reframe that. And we can provide, as a workplace, a safe space for others to seek help by bringing forward access to resources, what resources available, talking about it in the workplace, really trying to outline what our benefits and our structures are that support individuals who are in recovery or seeking recovery. And so there's a lot of opportunities in the workplace that can change that. And so as we think about what a recovery friendly workplace is, just provide a quick definition here that sets the stage for what we're trying to do. Recovery friendly workplace is a workplace where employers and employees intentionally work together to create policies, practices, and a culture that support employees who are in recovery from or affected by substance use disorder. And a lot of it has to do with culture, how we set that up. And there's a number of different ways that recovery-friendly workplaces can create that culture. We think about building that supportive environment and how can we do that? Looking at prevention opportunities. How can we reduce risk? Thinking about what our employees are facing on a day-to-day basis. Can we address any of those risks and reduce them? Thinking about training about substance use disorder and opioid use disorder so people really understand what it is and how we can find support. And this, fourth bullet is really thinking about those employment policies, which obviously we're diving into again today. In this last bullet, the access to treatment and recovery support, it's so important to really outline what is available in your area. We have a program here in Michigan that many of you have gone through who are here today. You are designated as a Michigan Recovery Friendly Workplace. Maybe you're interested in looking at what that looks like to be a recovery friendly workplace, but I would love to share more details. We will be sending out, we have an informational webinar that's coming up in September that will dive more into what we do here in Michigan. If you're interested, I have put a QR code here. You'll get this afterwards, so no need to jump into it. We will send that out later, but I'd be happy to share how we do it here in Michigan. I know a lot of people are joining from around the country, which is wonderful, and we're so excited that you're here. There's other ways too to get involved. The National Recovery Friendly Workplace Institute is also joining us today. They do a fantastic job of bringing all of us states together as well, and so that we can all be educated in ways to support our employers in our area. The map shows a lot of other states who are also doing this work. So if your state is one of these purple areas, I invite you to please look out for your recovery-friendly workplace in your neighborhood as they are really trying to work to bring this type of information to their employers in their area. This is just a quick synopsis of a lot of the employers who have gone through this program here in Michigan. And we, again, will send this information out to you of how to get in contact with us, but we hopefully will be able to meet with you in the future if you're not already going through this program here, and we can share more details. But this is really why we are here today. It's so important for us to dive into the policies that support our employees, and our employers really need to learn how to do this in the most effective way. Joe McGuire is the executive director of the National Drug and Alcohol Screening Association, which is the largest membership organization for those operating in the workplace drug testing space. She has lent her experience to so many different task force and Colorado Governor's Task Force, the United Nations General Assembly, and the World Drug Agreements. She's been on the National Recovery Friendly Workplace Institute's board and really aligns with bringing a lot of this work to that space. So without further ado, I'd really love to turn this over to Jo because she is going to bring the meat and potatoes to today's discussion. And I'm going to stop.
Thank you so much, Nikki, and thank you all for having me today. I'm really excited to share this with you. So I'm just going to get my presentation up and going here. Hopefully you're all seeing that on the screen. And okay, great. Well, last week we talked about the why. This week we're talking about the what. If you missed last week, you did miss some foundational pieces, but I'm going to review some big critical review points with you that I think you just cannot miss if you're taking part in this, portion today. But I do suggest you get with Nikki and the team and get the recording of last week so that you can watch it. If you're serious about rewriting your policy and you're going to go through that process, make sure that you really understand. Last week, we talked about the legal foundations and what can get you in trouble, what can keep you out of trouble. So if that's not enough to spark a review of that, then I don't know what is. Today, we're going to talk about tips for workplace policy success. And we're actually going to go through the different sections of a policy that's kind of, as Nikki said, the meat and potatoes. Now, next week, we're going to really bring the recovery-friendly portions in on violations and consequences. So that is, again, another critical component. I don't want you to miss that part, because if you just do this week and then you skip next week, you'll have some gaps. Okay, so it's all going to tie together. But today we're going to talk about when and why you will test for substances. Next week will be the how. All right, today are the core components of the workplace policy, and how will your policy reflect recovery friendly values. And so then everything that we do again next week is going to kind of bring it all together. So this is my disclaimer. I am not a lawyer. I am giving you the best advice that I can give you based on best practice in our industry, and with 17 years of experience in this industry, almost 18. I'm getting up to that 20 mark here pretty quick. But you will need to run any policy changes that you do have past your own attorney. Now, I also add in that should you do that, which you should do, not all attorneys are experts in drug and alcohol testing. If they look at the policy and say, I don't like this, I don't like the way you set up random testing, I think you should test one person on a random basis. I'm going to talk to you about that a little later. I've heard that from a ton of attorneys. I always tell people, if your attorney says something that directly contradicts what I tell you today, please get us on a phone call together so that I can explain to them drug testing law, because they don't all know that. I mean, even employment attorneys are not experts always in drug testing law. There are a few that are. If you're with certain law firms, they've got it down pat. But a lot of your local folks and stuff like that, they just they do things out of an abundance of caution that sound good to them, but they could be directly violating unintended. So I'm happy to always speak with them and say, this is why we don't do that. And they go, oh, I didn't know that. So anyway, don't rely on me for legal advice, but it is still very good advice. I just want that reminder. I know that Nikki already said this, but everything that I say to you today, I want us to run that through the grid of recovery friendly mindset. Okay. So I'm going to put some things out there in the policy content. You might go, that sounds really hardcore and not recovery friendly. Tell me, ask me the question, say the thing, type it in the chat or however we're set up here today, because I want us to be thinking about how these things balance each other out. And there's no one set of language, there's no one answer to get this right. There's just not, because recovery is a spectrum and substance use disorder is a spectrum. Your workplace is on a spectrum of what workplaces need and don't need, as far as safety sensitive and security sensitive, and none of those things. And so we nothing is ever going to be a perfect cookie cutter solution that you can just drop in the box and it fits for everyone. We have to have conversations. You have to make decisions. You have to think about this. So it's not out of the box ready like the Betty Crocker cake. You've got to bake it from scratch, but it can be done and people do it every day. All right. So I want to give you that encouragement. Little review from last week. What really works is taking a balanced policy approach. The workplace policy determines what happens in court when something goes wrong. Sometimes we tend to think of the policy as this is what we do to get people to comply and do what we want them to do. And that's a part of it. But the reason that we have it and the reason that it is so important is because it is going to go to court with us when someone challenges our policy, usually after a violation, and says it's not fair, says it's discriminatory, blah, blah, blah. And so we want that policy to be able to hold up in court. So to do so, there's some core components. It must be current. It must be clear. You must follow what it says. You can't just create it and then go do what you want. And then employees must be aware of it. And we'll talk about ways next week that you can remind them of the policy consistently. But it is their responsibility to follow it. but it's your responsibility to make them aware of it. So we're going to talk about in this series how those things go hand in hand. I also spent a lot of time last week on this, but this week I'm just going to drop in a quick reminder. There are a lot of things that you need to consider when writing your policy that I won't cover with you, such as your own state laws. Now, last week we talked about what Michigan has in place for state laws because this session is based in Michigan, but a lot of you are from around the country and we didn't get into your state. So make sure that you know what those drug testing laws specifically say. If you need help with that, reach out. I'm happy to refer you to people who do that every day. Make sure that those state drug testing laws include what has your state put in place for employers if there's a medical marijuana program or a recreational marijuana program. Some of them have inserted language that can make testing a little restrictive or says you have to do it in a certain way. Like in California, it needs to be a lab-based oral fluid test that detects the parent drug, right? So there's these things that are out there that everybody needs to consider. Union agreements need to be considered. Are you under DOT rules and regulations, which is our very next slide. If you have employees who are subject to the United States Department of Transportation safety sensitive testing program, they must have a completely separate policy from your non-DOT employees that are everyone else. Okay, those have to be separate and distinct. They cannot be combined in one document. They can't be like one document that has a paragraph that says DOT and non-DOT, DOT and non-DOT. That's considered confusing. DOT states that you must have a separate, distinct policy for DOT and a separate, distinct policy for non-DOT. So if you're in that category, it's just the way of life for you. You have to run and manage two different policies. Your non-DOT policy can be a lookalike program, and it can have all of the same similar components and just kind of make life easier for you. But it just depends on what your role is, your employees' roles are and how they function. And then this one is critical, and I probably don't spend enough time on this topic as I should in some of my presentations, but we are in an era where if you end up in court, an attorney knows to say, yes, but did Mr. Jones in this specific role require to be treated as a safety sensitive employee, or were they really doing something, under which this policy should not have applied to them? Now, that is really challenging. Your policy is going to encompass all of your employees, and we're going to have a mission statement. It's going to talk about why safety matters. But what we're seeing in court cases is that attorneys are getting, they're sort of parsing safety sensitive with non-safety sensitive. So it's just something that needs to be addressed, and it can be addressed in the mission and purpose statement. However, we do find that companies are on much more solid footing if they go through the positions that they offer and note in the position description whether or not this position is beholden to safety or security sensitive protocols. Now, I think I told you the story last week where I had a receptionist come in for a drug test, and she was falling out of her chair. She couldn't stay in the seat. And she was a non-safety sensitive position. She was supposed to sit in a chair and answer the phone. She was slurring her speech. She dropped the phone. She fell out of the chair. Was her position safety sensitive or security sensitive? No. She was a receptionist. But did she need to work in a safe manner? Yes, she did. Did she need to stay in her seat and and be able to articulate her words? Yes, she did. So there are ways in the position description that you can articulate. While this is not a safety or security sensitive position, we do expect employees to work in a safe manner that protects the workplace, right? So these are things that that are just legalese I get. But at the same time, we should pay attention to those if possible. If you've got 5,000 employees, this can be difficult. If 3,000 of those have different position descriptions, but by and large, you're usually looking at maybe 5 or 6 different position descriptions that can cover, like, CEO level, manufacturing group, administrative staff, or whatever have you. So, just a word of note on there. Okay, let's get into what are the earmarks of a good policy. And now we're going to start diving into different segments of a policy. So, what I've done is I've taken the first section of a policy, the core statements, and I'm giving you some examples of what those can look like. And we're going to talk about why they say what they say, what that does, why it matters. And this is a segment where I want you to really hear me on this. I welcome your feedback and your comments, your input, your questions. Now, I can't personally be monitoring the chat over here while I'm going through this because I can only have so many screens open at a time. But if Nikki wants to chime in and let me know you've got a burning question, I'm happy to kind of go through that as we talk about these segments. So the first section of your policy is going to be the purpose and mission statement. Spend some time on this. If your company has a mission statement, that should be a part of this, as well as the purpose and mission statement for your safety policy. Okay. And while a lot of folks will refer to this as drug and alcohol policy, and it's not that I never do because it is a drug and alcohol policy, it's also, it should be right in with the safety policies of the company. So it is a safety policy. Sometimes when we're doing these, we start parsing out, should we allow this drug? Should we not allow that drug? Is this drug legal? Is that not legal? Do we think that's okay? That's not what this is about. This is about safety. Can people work safely? And that might help keep us up out of the lower argument that we really don't need to always get into. But any discussion, I say, can be productive if we handle it correctly. All right. So for the purpose and mission statement, we're going to explicitly describe what is your agency's mission and how will substance use impact the accomplishment of that mission. We're going to review the adverse impact substance use has or could have on your agency. And then I want you to think about personnel records, security clearance revocations. Would any of these items be impacted, like EAP records, Merit System Protection Board actions, other items like I keep saying union agreements? Don't forget about those types of things that you might be beholden to. Are there examples about that have to do with past public health, safety, or security risks that have been experienced in a company? I am a firm believer that we don't need to change the policy every time a weird incident happens that's a one-off. I don't think you need to now run to the office and change the policy to make sure that never happens again. When you're dealing with human beings, stuff happens, right? But how did you put the policy into practice? What lesson did you learn? What can you use as an example to pass down to future employers or managers that may replace you someday? How do we carry our history, make notes, documentations on best practices in your workplace? Sometimes these things aren't necessary because it really was just a weird anomaly. But those are things you can consider and think about, especially if you work with a team on reshaping your policy. So the preamble is going to focus on the magnitude of risk for even one employee. And that's where we have to really think about what is the risk factor to your workplace on people working under the influence. Listen, I have folks who speak to me about this and say, we're in hospitality and it doesn't matter if people work high. And I hear that. And that might sound a little surprising to you, but I do hear that. Um, Folks will say, that we're just Burger King. It doesn't matter. And I shouldn't call out Burger King. We're just anything. Look, I was at a donut shop that we all know and love. And I was at the drive-through. And the kid behind the speaker just could not like he couldn't get that I just wanted a box of mixed donuts, one box mixed donuts. Couldn't get it. Asked me to pull to the window, stared at me for a solid 8 minutes. I was counting. Yes, I was counting because I was already annoyed and just couldn't, and I said, I need your manager. When he switched places and the manager came forward, I smelled the pot, and the manager was no better. And they were about the same age. They were probably somewhere between 17 and 19, somewhere in there. And I was like, you know what, y'all? You need to stop smoking the weed during work hours. And they started laughing. They were like giggle. Then they got the giggles. And I'm like, all right, bye. And I left. So you might think that, we're just fast food. It doesn't matter. It matters somewhere. And also there's fryers in there. There's equipment in there that folks can get hurt on. But sometimes we take a look at what we do and we don't consider what could happen if the worst things happen. Your policy is about what is the worst thing that can happen and how do we prevent that from happening. So anyway, not necessarily a rabbit trail. I want to drive this home to you about how this matters. But then again, the last point, and not the least of which, consider consistent recovery friendly culture opportunities in each segment that we cover. So, in the purpose mission statement, these are going to be two examples. One is pretty simple, the other one is a little longer. These can be pages. I don't think it should be pages, but we'll just go through what this could look like. So, your company is, or our company is committed to protecting the safety, health, and well-being of its employees and all people who come into contact with its workplace or places and property and or the use its products and services, recognizing that drug and alcohol abuse pose a direct and significant threat to this goal. Our company is committed to ensuring a substance-free working environment for all employees with support for pathways to recovery. That's a very simple, broad overview and a nice example. You're welcome to screenshot it if you like. By the way, I took my sample policies years ago from the SAMHSA website, and I basically just took that and used it as my template. But over the years, I've made tweaks and improvements and additions based on my experience. So I didn't just like create this language out of nowhere. Getting a little bit deeper, more wordy, and I've seen some, like I said, that are much more lengthy, and that's great. Our company has a vital interest in maintaining a safe and efficient environment for its employees, clients, and customers. Employees who are under the influence of drugs or alcohol on the job pose serious safety risks not only for the user but also to coworkers and others. The possession, use, or unauthorized sale of an illegal drug or alcohol may also pose unacceptable risk for safe and efficient operations. Accordingly, it is the right obligation and intent of the company to maintain a safe and healthy environment for all employees and guests and to protect company property, equipment, and operations. The company has adopted a drug-free workplace policy to ensure that our business is functioning safely, efficiently, and cost-effectively. In doing so, the company will comply with all federal and state drug-free workplace requirements. This one is a little bit stronger. Again, there's a lot of flexibility in here in language. This one is going to be a little bit more, you can tell, perhaps on the zero tolerance side because it's got some stronger safety statements. However, you can combine the language of the last two. I've seen many policies, and I think they must have come from someone that was kind of putting out like sort of templates where they go in and they quote the science and the statistics and the data for safety and drug use in the workplace and this and that from Department of Labor, et cetera. Some of the things that I've put in previous presentations, and I'm like, oh, it looks like a research paper that they turned in. And that is perfectly fine too. People can, any company can do whatever they want. Let me just take a step back with those who might have missed last week. There is no rule of law in the United States that says what an employer absolutely must have in their workplace policy at all. There's nothing that governs this federally. Some states, and this is where you want to check your state law, some states require you to follow DOT practices and follow a DOT model program. But as far as what goes in a policy, there's nothing that governs it until you get to court and there's a court case and the judge can say, you didn't have this, you didn't have that, you should have had this, you should have had that. If you never go to court, that's fine, that's great. But that's why last week I gave a lot of examples of what were the earmarks of what has been successful and what has failed in court, because we don't have anything else to go by except for what judges have ruled. And you kind of feel bad for employers that have lost in court unless they did something completely stupid, when they just lose because no one told them otherwise. But anyway, at the end of the day, it's all so flexible and there's no right and wrong. Just cover your bases. So before we go into the next portion, does anybody have any questions on this section? Any comments, anything you'd like to bring to the table? Okay, I'm going to move on. All right. So we're going to get into now the portion of this policy that's going to address drug testing. And I know there's some people out there who are averse to this, but I want to make a case for this. It is a vital piece of your policy because it's a big piece of your puzzle that you're going to use to help protect you and help protect the employee who is in trouble. Okay. And when I say in trouble, I mean they're struggling with whether it is an identifiable, diagnosable substance use disorder, or they're struggling with behavior they're on the path, right? We're going to detect that because anybody who partakes, and because we're in this era of legal marijuana, I don't ever want to villainize anybody who makes certain choices. That is not my role here, and that is not what I'm trying to do. It's legal, and if we're going to treat it like alcohol, then I have to say, if my neighbor has a glass of wine after dinner and the lady next door has a joint after dinner, if that's what the law allows, that's not what we're judging here in our workplace policy. However, my neighbor with a glass of wine and my other neighbor with a joint after dinner, they both should know that when they go into the workplace the next morning, they should be prepared to work safely. And if that adult use crosses a barrier where they can't do that thing, they can't come in the next morning prepared to work safely, then we have a problem and we could be on the way to a worse problem. So ignoring violations of our drug and alcohol policy could perpetuate either an oncoming substance use disorder or one that's already diagnosable. And let me just say, I'm using those two substances as an example, but this can go for your oxycodone, your Vicodin, all the way down the line. All right. But this is a tool that reinforces the policy, but should not be used to abuse or discriminate. It's not the hammer of the policy. HR enforcing the policy is the hammer, but it often does get used that way. So I want to just address that with you up front. Who qualifies under this policy? All right. So to whom does it apply? Is anyone exempt in this policy? So is it all full-time and part-time workers? Is it contractors and subcontractors? Sometimes that gets a little iffy depending on how you use your workers. Is it for seasonal employees, vendors, applicants? Vendors is always a really big question that folks call and go, can I force my vendors to adopt this policy? Often the answer is no, you cannot. Now it depends. There are exceptions to this. Does a vendor come into your facility and provide a service in your facility? The answer might be yes. Is it the kind of vendor that drops stuff off on the dock and leaves? No. However, what you can do is when you have contracts with those vendors, you can insist that they adopt their own policies and follow them, and that their failure to do so does not make you liable or responsible if they cause an accident or an injury on your facility, right? So there's these little things that you can do to protect yourself there. But in your policy, you need to outline who does this policy apply to. So here is, again, here are a couple of examples. So this policy applies to all job applicants, full-time and part-time employees, and contract employees of the company when they are on company business or on company premises, including but not limited to all properties, facilities, land, platforms, buildings, structures, fixtures, right? And it includes vehicles, whether owned or leased by the company or for company purposes. So this is really all-inclusive language that I really like. The policy also covers the use of drugs or alcohol while off company premises if the employee is under the influence as defined in this policy when representing the company. And I think this is really important language right here. All company property will be subject to search at the discretion of the company. Do not leave that line out. Don't leave that, especially if you have cars, trucks, anything like that, lockers. If you, and we do have there's some language coming up about, I think, lockers, or maybe that was a policy I was reading yesterday. Sorry about that. I think it is the policy I was reading yesterday. But you want to think about, if you give an employee a locker to use, does that become their property? Are you forbidden from searching that locker? Or is that still company property and you have a right to search that locker? So those are things that you need to include in the policy so that you don't get yourself in a situation where someone says, no, you gave that to them. They had used it for 5 years. They had they had property rights to that locker to be their own property. You think that sounds crazy? It's not crazy. I live in Colorado, trust me. Um, if I have a renter in my home and that renter is here for more than so many months, that space becomes their property and I am not allowed to enter it. I'm not allowed to look in it. I'm not allowed to do anything with that room in my own home. So these things can be real based on what state you live in. All right. So then additionally, the last section, regardless of the event or situation, employees are always responsible for their actions and behavior at company related events and activities. Do you send your employees to vendor shows? Do they go out and have customer meetings? Are they having a lunch with a client and alcohol may be consumed? Did they do the margarita flight during a business lunch and then start spilling company secrets or acting out of line with what they should be doing in a business meeting, or getting in their car and driving from a business function? We got to think about these things and how they apply in these situations. Are applicants going to be covered by your policy in so much as the company has extended a conditional offer of employment? So there does have to be, for sure, a conditional offer of employment made, but I want you to think about this, and I'll give you an example. Let's read the second portion of this first. Applicants are not entitled to company paid retests or any other service that may be made available to employees in this policy unless stipulated by applicable state or federal law. This matters. I want you to take a screenshot of that language right now, or you'll get the presentation later. But why does this matter? We had a spate probably about 10 years ago. I actually heard of it happening again recently, so I don't want you to think it's completely in the past. It's just people who figure out how to not go to work figure out these schemes, all right, and it actually can work for them, again depending on your state law. But here's what the scheme was. So applicants in a particular state would go and apply for the job. And then as an applicant, they were subject to the drug or alcohol test. Usually it's just the drug test because alcohol being tested for pre-employment is very rare. So so they would then be subject, they would get a conditional offer of employment. And not all of them were conditional on the drug test. They just said, okay, you look great. We think we're going to hire you. Your start date's likely going to be, August 15th. Everything looks fine, but you got to just take this drug test. It's a technicality. And then they would fail the drug test. Okay. And then they would go to the workplace and the HR person would say, sorry, you failed your drug test. You're not hired. And they would say, no, you already told me I'm starting on August 15th. You told me everything was in order. You told me the drug test was a technicality. They would file for unemployment and they were winning their cases, and the company was having to pay out unemployment for 90 days on the applicants. And it was like a whole slew of these that happened. People got smart to it, and it actually started spreading to other states because they were like, hey, 90 days of free money. I don't have to go to work. And all I have to do is go in, fail the drug test. As long as they did not have it in their policy that this was contingent on passing the drug test, I win. And remember last week, I talked to you about how culture spreads out into the community and people are aware of it. There were networks of folks they were telling their friends, and friends and family were all getting in on the deal, and these companies were being liable for hundreds of thousands of unemployment claims because they didn't have this protection. So these are the kind of things that I want you to understand matter in the language and in your practice to protect yourself. So they might seem like something minor, but this is why we're here today, right? To learn from these things. Okay, now we're going to get into boundaries and expectations, and this is the longest portion of your policy, and it is going to take us the next 2 weeks to cover this, so hang with me because all of this matters. All right, what is acceptable behavior and what is not? Drugs, illicit, prescription, synthetic, we got to talk about all of this stuff. Alcohol, paraphernalia, being under the influence, and unsafe behaviors. And also, I always say this, I apologize if you hate feet and you hate toes, but I love this graphic. So just bear with me, and my apologies to those who can't stand that. Okay. So in the boundaries and expectations, the company employees are prohibited from, and here's where you have a lot of options. Okay. I'm just going to give you one example, and then we're going to just talk about some things. So you're going to be prohibited from being under the influence of drugs as defined in this policy. For example, a confirmed positive drug test and or demonstrating the signs and symptoms of being intoxicated by drugs. Being under the influence of alcohol as defined in this policy, for example, a breath alcohol content of 0.02 or higher as demonstrated by an alcohol test and or demonstrating the signs and symptoms of being under the influence of alcohol. And then we're going to have an alcohol use exceptions, and we're going to go over that. You're prohibited from testing positive for drugs or alcohol and from failing to notify a supervisor or manager if the employee believes he or she is under the influence of drugs or alcohol. So we're going to get into self-reporting in a minute. This can be a lot longer. So there can be a lot of things that are added in here. And if you have any questions on that, just ask me. But some things that I want you to just stop and think about. What is the legal limit for alcohol violations in your state? Don't just take the language that I had there and boilerplate it into your policy if that's not the legal limit in your state. Okay, so that's what you're looking for in that portion of the policy is what applies to where you live. And it again, maybe I should say where the company lives. So whenever we're talking about policy items, it's where does your company reside? Where is your brick and mortar? And the components of your policy fall in line with where your brick and mortar sit. So that's an important distinction that I want you to understand. It's not where your employees live, it's where your brick and mortar sits. And if you have multiple locations in multiple states, each one of those locations need a policy that's compliant with their state, and those state laws need to be enforced for the employees that work at that location. Okay, so what I mean by that is if you are on the Michigan Indiana state line And that's probably a bad example, but there's let's say you're on the Indiana side. Indiana doesn't have full legal marijuana like Michigan does. If your company's based in Indiana, but your employees are driving over from Michigan, what matters is Indiana law, not where the employees live and what their permissions are. So hopefully that makes sense. Okay, so you're going to check the legal limits, and then how will self-reporting be addressed? Now, that was a little short bullet on the previous slide, but this is a big area. Is it self-reporting of, hey, I'm under the influence? Or is it self-reporting of, hey, I am a person in recovery. I need to go to my AA meetings every 2 weeks. I got to leave work because they alternate and it's during work hours. I can't find a meeting that's off hours, which is rare, but I just want you to know, or hey, I'm in, like I'm in a day program or a night program or something. It also could be, hey, I take Adderall. How are you going to handle this? I just want you to know I'm going to fail my drug test for amphetamines every single time, but I have a prescription for Adderall. And once the MRO verifies that with my doctor, I'll be cleared, but I want you to know, right? Sometimes people don't disclose that type of thing to you. And then you don't have their drug test result for 4 days and you're trying to figure out what happened and you're freaking out. And then all of a sudden you get a negative. And every employer, and I'm telling you, after, uh, this long in this business, every employer calls up and says, "Why is this taking so long? Why does this take? What do they have? What can you tell me? Should I pull them from safety sensitive duty? Should I pull them off the line?" And we can't tell you that. Those are things that are protected by HIPAA. But at the end of the day, sometimes people do. And one of the things we saw last week in the lawsuits was folks that walked in and said, "Hey, I have my medical marijuana card. And so I just want you to know I have it. And if I fail my drug test for marijuana, there's nothing you can do about it." And right now in most states, that's not a protected thing. And taking an action against them just because they showed that to you, that is discrimination. So self-reporting can include a lot of different scenarios. How will you handle it? What does that mean? And are you going to reward self-reporting, especially if someone feels they're under the influence, or are you going to punish it? And I think a recovery friendly mindset says we reward self reporting. Now, does that mean someone says, "Look, I ate my THC gummy bears last night. I am still so high. I don't think I can do my job"? That's usually not what this means. Okay. What it usually means typically is, I had dental surgery on Tuesday. I thought I was okay with this Vicodin, and it didn't really seem to bother me, but now I'm here. I'm in the seat. I took it because I was having pain and I can't see straight, and I want to let you know. That is not a case to trigger a drug test. That's not a case for firing or termination. It's probably go home for the day and call me when you feel like you can work. Is that paid or unpaid? Right. So those are decisions you have to make. Now, the gummy bear thing could totally happen, and it's the same thing. Are we going to reward that or punish that? But what we want to do is we want to create a recovery friendly environment where people are not afraid to self-report for safety's sake. Because I'll tell you something, if there's fear of self-reporting and so people push through it and work through it, accidents and injuries are going to happen, and then positive drug tests are going to happen, and then punitive actions are going to happen. And if someone could have prevented that, it could be losing a finger, it could be hurting someone else, it could be falling down a flight of stairs. If we could have prevented that from happening because we had a more open environment, that's what we want to move toward. So I wanted to really spend some time talking to you about that because I think this area is a mind shift. It's a culture shift, and that's where we want to go. All right. And then thirdly, and we're going to get into this a little bit more on the alcohol portion, I think, but maybe the drugs to be tested for somewhere in here. Make a plan for transporting employees home in case you have a suspicion that they're under the influence, or for mobile on-site collectors in case of employee intoxication on the job. I cannot tell you guys how many times I have seen employees walk into the collection site for their reasonable suspicion test. The supervisor called up and said, "Hey, I'm sending Joe over. I think he's under the influence. He's acting, this way or that way. He's going to come get a drug test from you for reasonable suspicion. He'll be there in about 10 minutes." Joe has driven his own car. He walks in, he can hardly stand under his own weight. And I can't believe they put him in a vehicle and sent him, whether down the street or across town. And I've been in rooms with HR professionals. This one will like always stand out to me. I was in a room with a huge group of HR professionals, and I mentioned this, and one lady raised her hand and she said, "I don't get it. I don't understand why they can't drive to you." And I'm like, they're under the influence. You're suspecting that they're under the influence. They're acting in a manner that's unsafe. You're putting them behind the wheel. That makes you liable for what happened between there and my place. And it was the lights came on, right? Because I've seen that so many times, I'm telling this story to you in case it never occurred to you either. That doesn't make you, in any category of unaware. It's just something that sometimes we don't think about because we're busy doing our job. You're busy doing the job you were hired to do, not being a drug and alcohol expert. So I get it. But at the same time, it's my golden opportunity to say, if you can find a mobile on-site collector that will come to you and you never have to send anybody out, that's great. One of the ones that I remember the most clearly is a company called me one morning and they said, our driver came up in the random pool today. He drove a passenger carrier minibus for senior citizens who needed to go to their doctor's appointments. And so it was a DOT, Department of Transportation qualifying test. And they said, "We want him to get going early before the day starts. He's got a really busy day. So can you be in the office a little early to get his test?" So I had to come in and unlock at 7 a.m. So unlocked at 7 a.m. He was there waiting for me. We got the test done. He was 3 times the legal limit on his alcohol at 7 o'clock in the morning, which is not unusual if someone has been drinking late into the night. It doesn't metabolize. He was an older man. He was very heavy. It doesn't mean he had alcohol for breakfast at 6 a.m., but he was still illegal. All right. So I called the company and I said, "I just spoke with him. He is over the legal limit and he came here in your company vehicle prepared to take the clients, go pick up the clients. He cannot get in your company vehicle and drive back." And as I was saying this to them, because I'm in the office by myself with him, he says to me, "No, I already picked up 6 clients and dropped them off." And I was like mortified, like, okay. And he already picked up clients on his way here and took them to early appointments. He can't get back in your vehicle. Well, the HR manager that oversaw the drug testing program was out of the country on vacation. And the people in the office said, "We don't know what to do. We don't have anybody to tell us what to do, so we don't know what to do." And I said, "Well, send someone over here to get your bus and then to take him to a safe place because he can't drive." And it took 2 hours for them to work that out while he sat there, and they were angry at me that he was missing pickups. I mean, like, we got to take a step back, folks, and think about safety, 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 and how to prepare for these things in advance, because the time you want to be preparing for it and figuring out the solutions is not the moment that the weird thing happens. All right, I think enough of that. Let's move on. Okay, we always want to take ADA into consideration, especially if it's embedded in your state law for people that are considered um, in the American Disabilities category because they've already been identified with a substance use disorder. Did you know that this is protected in some states? And it's only protected in those states if that individual is in a treatment program, typically, and not currently abusing. But if they have a slip up that could remove the ADA protection, however, this is something you have to consider in self-reporting. So this is why you've got to check your state law. So I'm going to read this to you because I don't normally read slides. That's not my style, but because we're talking about policy stuff, I feel like it's really important to get these points across. So in accordance with the American with Disabilities Act, the company does not discriminate against any qualified, and that's a key word, individuals with a disability who are not currently using illegal drugs, or who have either successfully completed rehabilitation or who may be currently participating in a supervised rehabilitation program and are no longer using illegal drugs. Now, also, many states include alcohol in here. So I pulled this statement from a particular state, but some of these also include alcohol. So you need to know your state laws again. Nothing contained in this policy shall be construed to or be applied in such a way that its application will result in discrimination against any individual with a disability or handicap, as those terms are defined by the ADA. All right, so it doesn't entitle the employee or job applicant to violate any provisions of the policy. Something that I want to just be clear here is that this is where your self-reporting could come in. Like someone's in a treatment program, they may self-report to you, they have ADA protections, they're following the rules. So that's where you want to be sure you have those considerations and you're not behaving in a zero tolerance manner with someone who's doing the right thing. Okay. There's also things that can help you out as the company, like your medical review officer could provide a fit for duty exam in cases of behavior that could affect safety. That's a topic for next week, but it's just a note on this slide that I felt was important because I know this whole area can feel a little overwhelming. Now, as we look at policy language moving forward, I want to make this distinction with you. I think it's very important for us to understand this as a whole. Impairment in and of itself can be caused by many different things. All right. So stress can cause you to be impaired, going through a horrible divorce, an illness that you're suffering or that your child is suffering. And I think I told the story last week of the heavy crane operator whose son was in the hospital for a brain disorder. Actually, I might have told it at a presentation last week that was not yours, but this heavy equipment operator was demonstrating signs of impairment. And it's because his child was on death's door at a hospital. And luckily, this company did daily impairment tests. And he very uncharacteristically um, kept testing out of his normal range. They asked him what was going on. They found out his son was in the hospital, and he felt like he couldn't leave the job and be with his son because he would put his job in jeopardy. And they're like, honey, we have an EAP program. You can take family medical leave. You need to be at the hospital with your son. Get out of here and go be at the hospital, and you're not going to lose pay and you're not going to lose your insurance. But he was operating impaired. All right. However, intoxication is a specific type of impairment caused by substance use. So you cannot be intoxicated and not under the influence, but you can be impaired and not under the influence. Does that make sense? But the reason that I want you to understand these distinctions is because these are legal terms. So if you go through your policy and you're using the word impairment as a standard of measurement or a standard for taking action, you could get sued and you could lose very badly in a court of law because there is no impairment standard out there that can protect you with especially drug use. Alcohol is better because we do have some impairment standards for alcohol in the US based on states, like I mentioned, but don't use that as a level of measurement for drugs because all drugs are present in system testing, and we're combining the direct observation of signs and symptoms of operating while intoxicated to document what we need to do moving forward. So these are the things that I want everybody to be very acutely aware of. And if you send me your policy and you have said this person will be subject to consequences up to and including termination because of impairment, I'm going to go, no, try again. you have no legal standing for this policy. We're going to use the word intoxication or under the influence. All right. So here are more of our boundaries and expectations. Bringing illegal drugs, alcohol, controlled substances, or paraphernalia to work and or storing the items on company property, that's a boundary. That goes for every state right now, no matter what, even states with legal marijuana. That's a boundary. Possessing, using, manufacturing, distributing, or attempting to distribute, sell, or dispense drugs or controlled substances off company property that may adversely affect the company, the worker's job performance, or place at risk the safety and well-being of the worker or others. You can include on or off property. That, again, totally safe boundary in every state in the U.S. Even the states that have legal marijuana usually include this as a boundary in those statutes that actually protect employees' rights. So this is solid language that you can use. Abusing prescription drugs, which includes exceeding the recommended prescribed dosage or using others' prescribed medications. Now, this is something that I want to just put a little highlight on with you for a second. I grew up in the Midwest. And I grew up in a time of some poverty for my father, who was in the construction industry. And we lived in a very cold climate, just right there underneath the state of Michigan. And so we went through long periods of time when my dad was out of work. It was absolutely a dread for my mom if one of us got sick. There were four of us kids. I was the oldest. And I remember this like it was yesterday. My mom would go to our little teeny tiny family doctor practice that was like a remodeled house, 3-bedroom house, little teeny tiny. The doctor went to our church, so we saw him every Sunday morning. And if I got like a croupy cough, he would give my mom a big old giant bottle of cough syrup with codeine or whatever it had in there. And I would take it until I stopped coughing. And then when my sister got sick, she'd take it till she stopped coughing. And then my brother, and then my little brother behind him. And if mom and dad got it too, we'd all take that big old giant jug of cough syrup. In today's world, that is considered illicit drug use. So my kid gets prescribed Adderall. I'm having trouble staying awake on the job. I'm going to pop that Adderall pill. If you get tested and you test positive for Adderall and you go, oh, no, it's okay. My son had the prescription. So it was in my home. A doctor prescribed it. It's fine. No, illicit drug use. Okay. The reason I'm parking here for a minute, some of you are going, well, yeah, duh, Joe. But some of you are going, I never really thought about that. My wife got, you know, a muscle relaxer for after she had a car accident, and I strained my back. So I took 3 of her muscle relaxers until I felt better. This is a common practice, especially in the Midwest. So it would behoove you to teach your employees that this is something that is not okay and not tolerated. And if they fail a drug test, and they have a substance that is not directly prescribed to them, that is a problem. And I just think it's great education. And these are things that I'm going to give you ways next week for how we educate employees. And this is one of those places where you can insert that to help people understand ways of not putting themselves and safety at risk. So thank you for letting me go down that path with you for just a moment, and make sure you make a note of that. All right, switching, tampering with, or adulterating any specimen or sample collected under the company's policy for the purpose of testing for drugs or alcohol. Folks, I cannot stress enough to you that we are just in this weird era right now where people think that it's okay to bring their pack along their little bottle of fake urine or someone else's urine, have it in their lunchbox, have it in their locker, have it in their pocket. And if anything happens, they've got their little plastic specimen and they cheat their drug test and they're on their way. My little sweet 82-year-old father was asked by a kid in church to if he would, supply urine in a bottle for him for his next drug test. And my dad called me up and he goes, hey, this really nice kid asked me this, and I don't know why he's asking me. Would that be doing something wrong, or can I help him out? And I'm like, Dad, no. You can't help your brother out that way. That is not okay. So people just do this on the norm these days and don't think much about it. And I could tell you stories forever here, but we got a lot to move on to today, so I won't. But this is something that you need to have in your policy. And also, we're back again to checking your state laws because there are over a dozen states where it is some level of felony or a law violation to substitute a drug test with a fake urine specimen. Illinois being one of them, which is right there, your neighbor. So make sure that you include this language in your policy and that we're making sure that we protect the integrity of our policy and our testing program in this way. All right. Disclosing information related to a drug or alcohol test result and or substance abuse treatment referrals except as required in this policy. I like this language because people talk, and we want this to apply even to HR to let them know, hey, we're not going to spread around gossip. We're not going to share people's information. If we have someone that has a problem, this is going to be private, protected information. In fact, if you're in a DOT testing program, those records are the drug and alcohol testing records specifically are to be kept separate from HR personnel records, separate from anything else that has to do with that employee in a private, secure, locked area where nobody else can have access to them. That's how seriously DOT takes the drug and alcohol testing records. Like they have to be protected. So we want this language for employees to have the confidence that we're going to protect them should a problem present itself. So except as required in the policy by refusing to cooperate with the terms, failure to cooperate can be refusing to be tested, failure to provide a sample without a medical valid excuse, refusal to sign paperwork, right? Failure to show up and then failure to be reasonably available to test it once notified, like in cases of a random. And then the alcohol use exclusion we're going to cover right now. Alcohol use will not be tolerated at the workplace, but may be permitted at the discretion of management when employees are representing the company during professional functions. You go to a conference or some kind of celebratory event. However, alcohol consumption by employees will not be permitted on company property. The company expects employees to exercise good judgment at all times when representing the company. At no time are employees permitted to be under the influence of alcohol or to operate a motor vehicle while under the influence of alcohol. And that's important because a lot of companies just kind of tend to forget the vehicle portion of their business. So what I have here is just a little grid that can help you make some decisions. Will on-duty alcohol use be permitted? By and large, that's no, but there are exceptions, and I'll circle back to that in just a second. Who can or must authorize on-duty alcohol use? Who is the supervisor? Is it the company owner, CEO? Who is it that's going to decide when there can be on-duty alcohol use? Will drinking be permitted at company-sponsored events? That's a question we have to ask. Will drinking be permitted at professional functions meetings while traveling or entertaining on behalf of the company? Like, what if you have a golf tournament? Are people going to be able to partake at the golf tournament? So we got to think these things through. Will the company pay for transportation expenses for an employee who is unable to drive? Are employees permitted to consume alcohol and operate a company vehicle, right? So these are all things that I'm going to ask you to make sure that you outline very clearly. You have answers to, because it matters. Now, I taught this policy workshop in an all-day course in the state of Illinois, upstate Illinois. And on the break, a group of people gathered around me after we did this section and said, you didn't address BYO Friday, I believe is what they called it. And I was like, what? And they're like BYO Friday. And now these are people that are from several different companies in the area. Most of them were construction, but there were a few other outliers. I said, what are we talking about? And they're like, well, every Friday we can bring alcohol into the office. And once we cross noon, like once we get to the lunch break, everybody can drink in the office. And I was so stunned. I don't even know what my face looked like at that moment, but I was like, you're joking, right? And they serious as could be, and they're like, no. And I said, when did this start? And they're like, it's, 1962. I mean, it had been going on for 50 years. And I said, okay, beer, wine, like liquor, what? They're like, it doesn't matter. But one girl goes, you can't, if you're out on the job site, you can't participate, but it's only people in the office. And I go, okay, what are you doing about driving home after work? And they just kind of all look at each other and look at me and shrug their shoulders like, oh. So I get that there are some places I now understand that culturally things happen that are just not what I am used to. I have the same things here for you. Okay. So this happens. So the thing that really got me was there were no guardrails whatsoever. There was nothing that said no hard liquor, don't drink after 2 o'clock so that everyone's safe to drive home at 5, whatever. I mean, that, and that's not even a real science right there. I'm just giving examples. Like there was no parameters, there was no boundaries. It's bring your own alcohol in on Friday. Once lunch hits, everyone goes home sloshed. Woohoo. I hope they still don't do that today, but I could be wrong. So these are things be thoughtful about. Think about your culture, think about what could happen, and make sure that you're being very clear and you know what's coming. All right, so our next segment is going to be reasons for testing. Right now, I just want to ask the room if you guys need a break. We can take a quick 5-minute break and everyone can sort of stretch, get your biology taken care of, get a refresh your water bottle, and move on in 5 minutes. Does that work, Nikki?
Yes, I see a break please in the chat. So big stretch
Okay.
break, thumbs up, clapping.
Okay. All right. I'm going to start that timer now, and then we come back. We'll see if anybody has any feedback before we move on.
Perfect. That sounds good.
Starting now.
Sounds
All
good.
right.
Back at
Thank you.
12:17. Thanks,
All
Joe.
right.
Yeah.
Okay, now that you've all hidden your Mad Men style drink carts in your office and we're ready to start again, does anybody have any questions before we move on to the next section? All right, just pop in there if you do, and let's get going. Okay, reasons for testing that should all be included in your policy. And I'm going to cover some exemptions, but these should at least all be listed. Okay. So pre-employment, remember that's upon conditional offer of employment. Keep that language because of the previous story that I told you about. Random testing must be scientifically selected. Post-accident, define what constitutes an accident. Reasonable suspicion or for cause, we're going to go over that. We're going to go actually over each of these in depth. Um, Return to duty and follow-up are following a violation of the policy if someone is allowed to return to work. And then we'll get into each one of those so you'll know exactly what those means. Now, for pre-employment testing, what I'm going to do is I'm going to give you one statement that allows pre-employment testing and then another statement that's going to have some limitations on that, okay? So the first one is all applicants for employment with the company, including applicants for safety sensitive positions, will be required to submit to a drug test once a conditional offer of employment has been extended and accepted. All offers of employment are contingent, and this is the language that you need to have in there. All offers of employment are contingent on a negative test result. This is to avoid that payout. Applicants may be required to sign an acknowledgement and consent form. A positive drug test, failure or refusal, failure to sign the acknowledgement, the effort to tamper, etc., are going to disqualify the applicant. Candidates that fail the pre-employment test may not reapply or be considered for employment for 1 year. That can say 30 days, it can say 90 days, it can say whatever you want it to say. So that's language that you need to decide what you want it to say. Applicants previously employed by the company, regardless of the length of time they were away, will be subject to a pre-employment drug test as outlined above. That's a standard practice in the DOT rules. And some of them are 30 days. Like if you're out for 30 days, then you have to pre-employment drug test when you come back. Some are 90 days. Some actually don't have it. But it's kind of standard in the industry that employers, they've learned that, and they're like, you went to Europe on a backpacking trip, you're coming back, you're going to do a pre-employment drug test before you and come back into the random pool. So it's just an idea there um, for a best practice. Here's the exemption language. Applicants for employment with a company, unless safety or security sensitive positions, will not be required to submit to a drug test as a condition of employment. However, all employees are subject to random reasonable cause and post-accident testing as outlined by the policy. As such, applicants will be required to sign an acknowledgement and consent form. Something that I highly, highly recommend if you're going to drop the pre-employment test, at least keep the option to perform the other types of testing. Now, post-accident and reasonable suspicion should not even be a question. You should always give yourself the option for post-accident testing and reasonable cause testing, because that takes you the liability off of you when something bad happens. Random testing is optional, but I'll tell you, there is not a better deterrent on the planet than random drug testing. Now, something that I also just want to mention briefly, I personally think it is wholly and completely unfair to not warn an employee that you're going to not do the pre-employment test, but then you're over here going to do all of the other tests. In fact, you can't legally do that. You have to notify them that you're going to do it. It is confusing to an employee. It's confusing to an applicant that, hey, I can be using marijuana to get this job, but then all of a sudden they're going to slap me on a random test or a reasonable suspicion test or post-accident test. I'm going to lose my job. So if that is your choice and that is how you're going to operate, and I get all the reasons why people make the choice to do exactly that, it must be communicated very well and thoroughly and give the employees time. So what I mean by that is, if you are not going to require the pre-employment test to hire them, but they're going to be in a random pool and get selected on a random basis, they need like a 90-day window once they have the job to cease use and make sure that they can pass a random test, or that is unfair. And you really have to do the same for post-accident and reasonable suspicion. If you're not going to require the test up here, once they get hired, they need to understand you have like either 30, 60, or 90 days before you are subject to this. And if anything bad happens in the meantime, company, that's on you because you didn't require the pre-employment test. So these are things that we are not often thinking about when we take away the pre-employment test. You're then assuming all of the liability and responsibility and culpability, which is a different legal term, for anything that happens in the meantime of when a testing event is to occur. So it's just something that totally protects you. And in many states, workers' compensation will not make you liable for workers' compensation if the employee chose to be under the influence during work hours. Otherwise, 100% of that is on you, and it is all your liability. So these are things that you need to think about when making these decisions. And then employees that fail a drug test may be eligible for second chance programs after evaluation by a qualified substance abuse professional. We'll get into that whole arena at a later time. Something that one state enacted that I thought was really cool, and I put it in my slides because I was like, that's a really great communication tool, is that they included in their job application, and this was the state did this for state employees, the fact that use, possession, or being under the influence of medical marijuana at work during work hours was prohibited. They put it right in the job application so that applicants can come back later and say, we didn't know, we had no idea. Now, I will tell you that they also chose not to pre-employment test. but they had the notification in the application, and then they did have a post-accident and reasonable suspicion testing protocol. So there are dozens of ways to put this all together. You need to do what is right for you, but keep safety in the forefront and keep your liability and culpability at the forefront of those decisions. All right, random testing. Let's go through what this means. So the company reserves the right to conduct random testing. When random testing is conducted, all employees may be subject to randomized unannounced drug testing. Now listen, you can make this for everybody, or if you have different levels of safety and security sensitive, you have the right to only do that group of people, but you have to identify what that group is and why others do not have to do it. That goes back to my position description warning. So if you're going to break them down into separate entities, that's fine, but everyone in that bubble has to be in the random pool, no exceptions. Okay. So here's an example. Like you have a small trucking company and the owner is a driver. He says, and I've seen this dozens of times, the owner says, I only drive if it's like a snow day and three employees call out and otherwise I don't ever get in the truck. But if three employees call out on a snowy day or whatever, I'm the backup guy. If there is a case where an individual is stepping into those shoes as a sub and he carries a CDL, he has to be in the random pool like everybody else, no exception. And those are things that have court cases have ruled on them, and DOT has that practice, and et cetera. So you've just got to know that everyone in that bubble has to be in that pool equally. All right. Employees subject to random testing will have an equal probability of being neutrally selected for this testing. The company will not waive the selection of any employee who has been randomly chosen unless an employee is on an extended leave of absence when selected. And some companies don't even do that, but this is the better option. All right. Here's some clutch language right here. Random tests will be unannounced and performed at reasonable intervals throughout the year. The selection of employees for random drug and alcohol testing will be made by a scientifically valid method, such as a computer-based random number generator that is matched with employees' ID numbers. All right, I want to take a breath here and talk you through a couple of things. We hear in our industry all the time of small companies that just pull names out of a hat. Do not do that. It is not scientific. And anybody can say the secretary put mine on a blue piece of paper and knew that it was going to be me, and she draws my name every time. That's grounds for discrimination, and it's valid. No names out of a hat, no darts on a dartboard, nothing like that. It's got to be scientific. This is held up in court, so I'm not just blowing smoke at you. The other thing is, I've heard attorneys a lot say if you think someone is under the influence of drugs or alcohol, don't call it reasonable suspicion, just call it a random, tell them they got randomly selected. No, 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 no is the answer to that. Why? Because you then cannot prove that name was scientifically generated in a random pool. All you've done is single them out and discriminated against them and called it a random without confronting them and telling them we suspected you were under the influence or intoxicated. Okay. So randoms are strictly randoms, and reasonable suspicion does not come into this whatsoever. It is in its own capsule, and it is a very effective testing tool. All right, now we're talking about frequency. So are you going to test 50% of all of the employees in a year, which is the standard DOT frequency, 25%, 75%, some choose 100. You can do whatever you want, but it should be spread out throughout the year. It should be undetectable by way of employees should not be able to guess. So I had a big construction company that would call me up every year and go, we forgot to random test everybody. So we're going to do it between the week of Christmas and New Year. And it was 125 employees. They were spread out all over the state on construction sites. And I was driving from construction site to construction site, including being flown to another state. to drive out to a very remote location and stand in a trailer and test guys on the side of the road while they were on jobs. So, and they would give me like this 7 day window in between Christmas and New Year's because they just forgot. Every single time I would do that 3 years in a row, I would tell them, guys, please start spreading this out over the year. We know, we're sorry, we just forgot, it got off the radar. I will call you, I will remind you. No, you don't need to do that. Okay. Every single time, those guys had their pee in their pocket. They were just waiting for me to get there so that they could cheat the drug test, every single one of them. So bad practice, right? And it just destroys your whole safety program. All right, so define what this means, and then understand the names of individuals who are randomly selected for testing will be returned to the eligibility list for future selection during the same year. You can't do a thing where you go, okay, you got selected, you don't have to, your name gets to come out of the pool, everybody else has to be in there, because that's not an equal probability of everybody being chosen. Will some people be chosen twice in a row, 3 times, 4? Yes, because that's how random generators work. They should also go buy a lottery ticket if they get their third time in a row. But yeah, everybody has to go back in once the selection is made for the next draw. All right. And then you notify them, you give them so much time to get to the testing site from where your location is, map that out, tell them, it's 15 minutes from here. You need to be there in 16 minutes or whatever. But you need to monitor that because people do stop at the head shop and get their fake pee bottle and show up. We see it all the time. They buy their synthetic urine and then they go to 7-Eleven, pop it in the microwave, heat it up to 100 degrees, and then put it in their pocket and show up to the collection site with a warm specimen. Happens every single day. So please be reasonable about this. If you can use a mobile on-site collector just to come to you, that's the best way of doing it. All right. And then if the individual is in the middle of performing safety sensitive functions when their name is drawn, they need to cease their function, report for the test, and then go back to their function. That's how it's better to draw your random pulls like first thing in the morning or in the last 2 hours of the day, although not recommended. It's better to do it in the morning so you don't have people working under the influence all day, and rather than doing it in the middle of the day. So just a little tip for me to you. So things that you consider in this section: how often will you run it? Monthly, quarterly, annually? What does that look like? Who will make the frequency determination? It should be like 1 or 2 people that are working together if it's more than one. And because you don't want everyone's hands in when this is going to happen so that it becomes predictable. Who will manage that random pool? Is it going to be an HR manager? I highly recommend using a third party administrator. My industry is full of third party administrators in every single state who will just manage this whole thing for you. They'll just send you the list the first of every quarter and say, this is your list. It's your job to spread those out over the quarter and test them here and there over that 90 days and then start over in the next quarter. But a TPA really helps to avoid that appearance of discrimination or you're picking on me, you hate me, you just keep drawing me, whatever. And then again, I've mentioned avoid the predictability of the timing. Let's get into post-accident. This one will be pretty short. All employees who are believed to have caused an accident during work time are while on company business or on property, regardless of if an injury occurs, will be subject to a drug or alcohol test. You may keep that language, you may not, but here's some things to consider. Accidents that include any of the following will result in a post-accident test: a fatality, any injury that requires medical attention away from the scene, so like an ambulance comes, we transport someone to ER, an injury that results in lost work time or damage to the company in the amount of X. It could be $100, it could be $1,000, it could be $50,000. It depends on what your company does. All right. A post-accident drug test must take place within 24 hours of the time of the accident. A post-accident alcohol test must take place within 8 hours. And that is because of the time of metabolization of alcohol. That's a shorter window. Any employee who fails to report a work-related accident is in violation of this policy and subject to disciplinary action. Now, the only thing I'll say about this is look at OSHA. Make sure that you're being OSHA compliant on your post-accident testing. And also, this should be the post-accident test should only occur when the employee is responsible for what occurred or could be responsible for what occurred. What do I mean by that? The famous example that OSHA always uses, and they're right on this, is if an employee gets stung by a bee and they need medical attention, maybe they're allergic to the bee sting and they end up in the hospital, with the shot or whatever. That people will do a post-accident test and go, well, it was they had to be medically transported away from the scene. It has to be the fault of the employee. A bee sting is not the fault of the employee. They didn't do anything to cause an accident or injury or harm to the company. This was a special circumstance that was not their fault. So but now if it's a freak accident and it could have been the fault of any employee, test everyone involved that could have been responsible. If it's the person that got hit with a pole that was knocked over, it's the person that knocked over the pole, not the person that got hit with the pole, that has a drug test. We've seen cases where the company tested the person that was injured through no fault of their own. They failed the drug test, they fired them, they lost the case, and the employee walked away with huge settlements. So use common sense here. If you have any questions on that, please let me know. All right, reasonable suspicion testing. Here we get into some fun stuff. All right, employees will be required to submit to a drug or alcohol test when a trained supervisor or manager has a rational basis, whether from direct observation or reports of others. And I just want to highlight that from reports of others, that needs to be like really clearly identified. Oops, accidentally went to the next slide. So we have to understand what that means, and we'll talk about that in a second. So if there's a belief that an employee has violated the policy or is under the influence of legal or illegal drugs or alcohol, that has an impact on the individual or the work environment, then we can do documentation. It's not based on rumor, speculation, or unsubstantiated information. Referrals will be made according to procedures set forth by the company. So you're going to define this. So behavior that could prompt reasonable suspicion would be direct observation of reckless or risky behavior that may indicate the individual is intoxicated or under the influence of legal drugs. Direct observation of speech, odor, appearance that may indicate, again, they're intoxicated or under the influence. Reports of information that an individual was seen taking, selling, dispensing, or using illegal drugs, or telling other employees of being involved in such activities. Evidence of an attempt to alter a drug or alcohol test sample, or patterns of abnormal, erratic conduct, such as, but not limited to, signs and symptoms of intoxication, etc. Now, one thing I want to say here, there are lists that are out there that should be probably included in your policy. Some people disagree with me on that. It's okay. Of what signs and symptoms are, and they help a supervisor determine if someone may be under the influence. They also help the employee know what is going to be looked at when they're operating, to determine if they're operating in a safe manner. I think checklists are wonderful, but they have to be exhaustive. They cannot just be 6 things and that's it. It's not fair and it's not right. So it's got to be an exhaustive list. And also, we're not talking 10 pages. We could be talking about 2 pages, but not 10 pages. The fact of the matter is the signs and symptoms of someone being under the influence is finite. It just doesn't include the world. So this is not hard. But what I am saying is you cannot set yourselves up in a situation where you have, um, you've got 2 employees, they don't like each other, they don't get along, and one comes in and reports the other one for being under the influence because she's been angry at her for 6 days, and that's a sign of drug use and I want her tested or whatever. I mean, people make stuff up. That's not okay. What is the documented sign? So you need protections in place for if someone says, hey, I think Sally is operating under the influence. Okay, what is the criteria for that? That in that situation, a supervisor needs to document what is being reported and then get eyes on the situation themselves to see if that is also what they observe. If they cannot observe that in any capacity, then you leave that person alone. But if those signs are documented, maybe you got two employees who go, no, she's right. We saw it ourselves. Okay, now you might have grounds to say, let's do the test. But be cautious with that. Be careful with that. Be very, very delicate. The supervisors must be trained on the detectable signs and symptoms of substance use, and really should be a frontline supervisor that works with that individual who knows them and knows whether or not that behavior is out of character. That's really what we're looking for. So, but here's language that I also want you to see. Reasonable suspicion does not mean that the company must be correct in its belief, only that it has some rational basis for believing that the employee may be involved in substance use. If the individual is to be sent home after providing a sample, the company will make transportation arrangements. And then for liability reasons, you may not want that to be another company employee that takes them home. You might want to call Uber. There could be liability in a variety of different ways. Make sure a family member comes and gets them or something of that nature, but you want them transported safely is the bottom line. And you won't allow them to drive home if you believe, like, say they failed an alcohol test on site, but they take their keys and they go jump in their car and leave. You might have to call the authorities because like, hey, they just popped twice the legal limit. Now they jumped in their car and they're driving away. We got to notify someone. I would consider those productions. Um, but let me just stress this again. All supervisors should be trained to detect and document the signs and symptoms of substance abuse so they know what they're looking at. Training should not be, I mean, it should be conducted on a regular basis as drug trends change because new things come to the table. And then the policy and the practices, again, as I mentioned before, must work together. But I want to tell you this story. I don't think I said it to you last week. Um, but maybe I did. I apologize for repeating myself, but a person in my family used marijuana every day. Here in town, they drove a box truck. They said, my supervisor either knows I'm stoned every morning when I get in that truck or he's too stupid to tell. If he knows I'm stoned, he doesn't care. If he's too stupid to tell, that's on him. Employees understand that you are allowing them to make a choice, that you're making a choice every day to allow them to make a choice every day, and you're working together if you don't have boundaries and are enforcing those boundaries. So I really want just to stress to you how important testing for cause is, because I think a lot of us avoid it because all we can see is conflict and confrontation, and we don't like that so much. But this is probably the most critical test you could do outside of post-accident. So who will determine if there is suspicion? Does a supervisor, like a second person, need to verify and validate that you're seeing what you're seeing? When is training required? What training is required? There's a ton of training out there. Most of it's online, super simple. Or you could get everybody in a room at an annual safety meeting and train them with a live person. That's a lot of fun. Either way, everybody needs to get trained. And then what documentation will you required to back you up on this? Last thing I want to say is the U.S. Supreme Court has upheld workplace testing for cause in a landmark case called Skinner versus Railroad. And it states that an employer needs only something more than a hunch to test. Again, you don't have to be right. You just have to have something more than a hunch, and that something has to be documentable. An odor, an appearance, a swaying, a slurring of the speech, and you only need one. You don't have to hit two or three on the checklist. You need one thing because it's about safety. Again, if you're wrong, it's fine. Again, if they're impaired by something else, that's fine. Do your due diligence and think about what happens if you go to court. Okay, the next two we can get through pretty quickly, but it's return to duty and follow-up testing. And this is if someone has had a violation of your drug or alcohol testing policy, and you want to give them that second chance. You want them to be able to stay at work, come back to work. They would typically, the way that it sort of works out in the universe here, is that they would seek out a substance abuse professional that is licensed and trained for the workplace. We have those in every state. That person will evaluate them to determine, are they safe to work or do they need a class or a treatment program? So they're evaluating the level of the violation that we have here and what we're really looking at. Then they'll recommend when they are, they need to complete this course, I can refer them to it. They could take it on Saturday. It's an 8-hour class. On Monday, they can do their return to duty test. Or do they need to be in an outpatient treatment program? And we'll take it when that's done, or inpatient, whatever that looks like. Um, and then they get their return to duty test, and then once they're allowed to return to duty, then you may want to choose a follow-up testing program, which most people with SUDs welcome, because it helps with their accountability. It helps keep them on track, and every clean, or I should say negative test, is a victory for them, and they love that. So that's in most cases. I'm not going to speak for everybody as a whole, but generally that's what we see in our industry. So this you will have to work out. There are guidelines, there's boilerplates, there's really nice evidence in the DOT testing program of how this works. Decide what works for you. But this is something that I do highly recommend for those guardrails. And then substances to be tested. Now, this is one that next week we're going to talk a little bit more and get into a little bit more of how the substance testing works so that you can have real clarity on what to do and how to do it. But you do need the section in your policy that determines how you're going to test. Is it going to be laboratory based? Um, will you utilize instant results? When will those instant results go to the lab? And then what substances? So there's a list of things here. Some of these are more in vogue than others at the moment. But what does that look like? And when will this person be subject to these things or not? I am not a fan of policies that list 22 substances and then say these are the things we will test for. We're going to do a 22 panel and that's it, and they leave it that way for 10 years. Drugs come and go. They come and go. Now we do have our core, like our core group, right? Our family groups of drugs, for sure. But this is where your policy needs to have some flexibility. So I always advise having the phrase any other altering substances, non-medical use of prescription drugs or prescription medications not used by pharmacist instructions. I highly recommend that you include that so it covers, fentanyl pops up. You can't get your policy changed on a dime because of this or that, but you have the right to test for it. K2, spice, ketamine, all of these things that are coming to the surface. So leave yourself some leeway there so that you have options when needed. And that's just a strong word of caution. All right. A lot of companies are banning nicotine. I mean, with the trend isn't kind of like as hot right now as it was maybe about 5, 6 years ago, but we saw a lot of companies that were saying no nicotine on campus, and they banned e-cigarettes and vape devices. If you'd like to know more about that, let me know. But again, in your decision making, don't leave that out. And also remember that vapes are used for hard drugs, not just nicotine. So that's something. There's a lot of companies that have banned the use of vape pens on campus. So think about that. If you'd like to talk more about that, let me know. We mentioned this last week. I'll mention it again. If you'd like to make a marijuana accommodation, be very specific about to whom it applies, for what you're doing, what you're allowing. Is it on site? Is it off site? Work from home? What is it? Be consistent with it. Always know safety sensitive does not qualify for this accommodation. That puts you at risk as well as your employee. And then keep detailed documentation of those accommodations. Marijuana testing as of today, right now, as you're hearing my voice, medical review officers will not verify a drug test as negative based on information that the person has a medical marijuana card. But that could change with rescheduling very quickly. And at that point, that's when I think this will need to be treated similarly to Vicodin or oxycodone. I would include in the policy marijuana is an impairing drug because it is, and use does not contribute to the safety mission. So I would keep that in there, even if you make allowances, cover yourself so that you're just not opening the gate to like a mass abuse of your safety policies. So don't just use the federal language that's used in DOT and expect that will protect you. We saw a court case last for that I mentioned last week. When it comes to alcohol, you want to state that you will use current alcohol breath testing technologies. The company reserves the right to utilize other testing technologies because there are other things now, fingerprint testing and all kinds of stuff that's coming down the pipe. But know what your blood alcohol content will and will not be acceptable. Will you remove someone from safety sensitive duties for a certain measurement until they return to baseline? What does that look like? We could talk about that more in the consequences, but proceed with caution and make sure that you're considering what the law says. And again, the DOT model here is very helpful. Next week, we're really going to get into the violations and the consequences so that I can help you really navigate this in a manner that's recovery friendly. But we're going to look at what are the consequences of violating the policy? What language should you never use? All right. And what is possible? What are the procedures for determining if someone violated the policy? How does someone appeal a determination that an employer made? You need to know that. What do second chances look like? What does zero tolerance look like? What are suspensions and return to duty and follow-ups? And what are best practices around those terms? And I would really love discussion. So write some of these things down and let's talk about them. HHS or SAMHSA, Safe and Drug Free Workplace website to pull that language from, but you need to go through it and say what applies to me and what doesn't. Definitions of terms are there. Those are great. I don't need to feed those to you. I've seen policies where the definitions of terms are literally 16 pages, and I've seen one where it's a paragraph. I would fall somewhere in the middle. I like one page or 2 pages max, but definition of terms can be helpful if people don't know what you're talking about. And then you always, 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 you must have that acknowledgement and consent form. You don't want to implement a policy where you violate someone's right to illegal search and seizure. So hopefully you're all still with me on that and I haven't bored you to tears. I'm going to repeat that because this is important. If you implement a policy where you have not given pre-warning to the employee and you have not had them sign a statement that they agree to abide by the policy, that they've been made aware of the policy, you are violating their constitutional right to illegal search and seizure. When they sign the acknowledgement form that they've read your policy, they agree to abide by it, you now have a social contract that this person agrees to work in a safe manner and will abide by your policy, and that the specimen collection of their bodily fluid is legal. So you never put a policy in place without notifying your employees and having documentation that you have notified those employees, okay? And then I like the reasonable cause checklist in there. Again, some people don't like it and they get mad at me for it because they say it's unnecessary. I love it. Okay, it's up to you. I'm just going to run through a couple things. If you have questions, I want Nikki to shoot them at me. If you don't, I'm just going to keep talking. But I just have a couple more things that I just want you to think about. All right. So a lot of people just say, I'm removing THC from the drug screen. I'm afraid I'm getting sued. I don't want to mess with it. It's legal here. So let's get it out of here. I do think this is a bad idea because it increases your liability for accidents, injuries, and damages. We have a ton of data and statistics that show us that employees that use marijuana regularly have greater incidences of causing workplace fatalities, injuries, accidents, absenteeism, all kinds of stuff. We have those statistics. They go back for decades. They are still relevant today with more potent products. This has not diminished in any way, and frequency of use does not improve those numbers, just like it doesn't with alcohol. So I just think this is a bad move. I would really implore you to think twice before you do something like this because it just puts, again, all of the liability on the company, and it's not good for the morale of the safety program. What about increasing the limit? Let's increase that cutoff level. Joe, call me up and ask me what to do about that. The cutoff levels that have been set by HHS, Health and Human Services, the Department, U.S. Department of Health and Human Services. So what the cutoff levels rule out secondhand exposure and say this person is definitely ingested. These are ingested amounts and they cannot be impacted by secondhand exposure at this level. Why would you change that or take that away from someone? If you increase the level, you could take action against them when they really have been impacted by secondhand exposure. Don't touch the cutoff levels. Leave them alone because you don't know how much is too much and how much is not, what is safe. We don't know any of that, and it's highly individualized. So don't touch your cutoff levels, please, please. And then what would we allow recreational use of any other drug use for medical purposes? We know that we would not. We're very clear on that. So would we allow people to use recreational oxycodone? So we have to think about this and put it in perspective. People say, well, they tell me all the time, it's not exactly the same. No, it's exactly the same. Now we're getting ready to put marijuana into Schedule 3 where the oxys live. We have to think about these things before. I mean, we're giving special treatment to a substance rather than thinking about safety, and safety is where the decision lies. What about medical use of other illicit drugs or alcohol, which we've done in the past? Again, I think this is a bad idea. There has to be some boundaries. We've already seen decriminalization of psilocybin. We've seen it of other drugs. Even in my state, personal use of any drug is legal. So how do you make allowances for some drugs and not others? We got to keep this all right now together until we know more and we have legitimate medicines on these things. Okay, so with that, my long-winded, but I think pretty important conversation. If there are any items for discussion or questions, I'd love to take the next few minutes to talk about them. You can also reach out to me, joemcguiredandesa.com. But at the moment, I will stop sharing my screen and I would love to hear anything that you have to say.
So we do have some questions. I'm going to do the last one first because we just finished up on the THC. So the question was, what about keeping THC for cause and post-accident testing, but not for randoms that could focus more on impairment intoxication than off-the-job usage?
If you choose to do that, communicate, communicate, communicate. Again, I say, your policy creates a culture. So if you're creating a culture that, hey, this is okay until it's not, it is not fair to do that to an employee and say we're totally cool with this until we're not. Now you're totally liable for it. So how do you strike that balance? I'm not saying the balance cannot be had, but what I am saying is communicate that so that they understand you've got a bridge too far. And once they cross it, now you're doing XYZ for it. Is that a fair approach? Personally, I think you're trying to have your cake and eat it too, and you're trying to let employees have it their way, and you're trying to have your way. And the two things at some point conflict. To me, the best solution is be constantly communicating. We're not going to test you for it until we are. And they need to understand that and know that. And then you need to be serious about it and test when it does require. Otherwise, you have no safety standards. So that's just where I fall on that.
Okay, thank you. We have a couple more minutes here, and we had some great questions. So, one that was earlier on: if two employers have identical testing programs, but one embraces being a recovery-friendly workplace, what should be meaningfully different in the written policy? And this, I don't know, could go into the how, but
It
let,
is the how. This is all about the consequences for violations. One is termination, termination, termination. The other one is second chance policies, how we return people to work, what that looks like, and what that flavor is. And that is all of next week. But that is the key. If I had to sum it into one sentence, it's do you have a second chance policy or are you zero tolerance only?
All right. Another one is I'm wondering if you have perspectives on language or actions employers can consider as they have a return to work agreement that mandates testing, how they can protect the employee from being unfairly identified as in recovery.
So this comes down to really comes down a lot to your culture and how you're structured. Usually, if you have an HR professional who's a trained certified HR professional, they are very clear on confidentiality. They know that, they protect it, they understand it. And you're sort of in a lockbox with that person, and they know they've been trained on the language that they can use to even communicate with supervisors as to what we're doing, like accommodations that we're making. Um, but often in small companies, we don't have that boundaries, especially a lot of mom and pops are in families and they just tell everybody like it's kind of a free for all, and that's not good. So suggestions and recommendations, I mean, I would look at, can someone in the company get certified with any of the human resources agencies that are available? Because there's plenty of them. There's not just SHRM, there's a lot of different places. There's some that are geared just towards small businesses, and learn proper protocols for protecting these things. That's why I mentioned drug and alcohol testing records should be kept separate and away from the rest of the employee file, and in a just a complete separate area where no one else has access, because it is important for those protections. So we can talk a little bit more about that next week, but that's my upfront recommendation.
All right. And one more question before I go to hands up. Let's say that I had a coworker who is on a physician supervised MAT program, methadone, Suboxone, et cetera. What wordage should the employer's policies reflect?
Next week. We will
Okay.
cover that next week. Sorry, but Matt is on my list for next week and
Perfect.
we will go over it.
All
Yeah.
right. And I think I see one hand up. Artavia, did you want to come off mute? There you go.
Hi there. My question was when you touched a little bit on like if it's reported by a coworker and then management then needs to step in, how do we get leadership? Because there's a few leader levels of leadership under me. How do I get them trained as well on being able to identify that?
That's great. I would make it a requirement that all supervisors have to have this training. There are online courses. There's good ones and bad ones. So if you want to ask me, I will make some recommendations. But it needs to be at least a 2 hour course on signs and symptoms of drugs and alcohol. And taking an employee's word for it. I mean, I've had cases where the policy said absolutely not, we will never do that. A supervisor has to put eyes on it. And then people came back and said an employee walked in on a coworker snorting cocaine in the bathroom. No lie. Is that not a reason for them to report? Well, of course, that's a reason for them to report. Every rule we make has an exception. So what actually occurred? We just want to make sure we're not having tit for tat people that are not getting along and they're trying to, punish someone else or get them fired. So that's why it's important to have trained supervisors who can evaluate the signs and symptoms to get eyes on it and verify, yeah, we might have a problem, and then we can investigate from there. But those supervisors, it is so important for them to be trained because they're the people who see those folks every day and know whether or not they're acting out of character or out of their baseline. And there's some other tools that we can use to detect impairment as well. And I know I caution you against the word impairment, but I mean impairment that is not from substances or could be. There's some electronic tools. People can take little puzzle tests on their smart devices and determine if they're operating within baseline or not. But that's a really good question, and I'm happy to explore that further with you.
Yes, how do I reach you to explore that further?
It's Joe McGuire at Endesa.com. I'll just type that in the chat real quick, and I'm more than happy to answer questions as we can.
Thank you.
Yeah.
Well, thank you so much, Joe. We are a little over 1 o'clock, so I do want to be respectful of everyone's time. I did put on the screen, we've got our next session next week, which is our final section of this 3-day mini series. I will be sending out slides in the recording, so hold tight for that. And thanks everyone so much for your time. And thank you, Joe, for all of this. So much work for going into this, and I really appreciate you.
Thank you. See you all next week.
Sounds good.
Bye.
Bye.